Good afternoon all. As a kid, I played Where's Waldo? It's a game where you find Waldo in a crowded picture. As a conveyancing lawyer, my job is to find Waldo in a contract. It's to identify the risks in the fine print, advise on the potential consequences so that the buyer makes an informed decision when they sign the contract. That's just a quick blurb about our business. As you can see, our legal firm specializes in property and business transactions, so assisting clients with buying and selling of properties, buying and selling of businesses, and other commercial contracts and agreements. Now, this contract is an unregistered land contract. It has 286 pages. One sentence on page 24 gives the seller 84 months to settle. This means that the buyer is legally bound by the contract for 7 years and has to be ready for settlement anytime within that 7-year period. If the buyer doesn't settle on time, the seller can charge penalties and costs, terminate the contract, and keep the deposit. A massive risk given that the buyer's personal circumstances, borrowing capacity, lending policies, interest rates, construction costs are likely to change substantially within 84 months. This slide shows common expected and unexpected costs. Many of you, I'm sure, are familiar with the expected costs. But are you familiar with the unexpected costs hidden in the fine print? The numbers on the screen are very conservative estimates, often the best case scenario, not the worst. For example, the default penalty interest is 12% per annum calculated on a daily basis. So on $1 million purchase with a 10% deposit, you would pay $296 each day settlement is delayed. However, in the special conditions, penalty interest is usually increased to 14%, 16%, or even 18%. At 18%, you would pay $444 for each day settlement is delayed. Over the last 15 years, I have often witnessed buyers paying unexpected costs and penalties during that purchase process. Over time, I noticed two recurring patterns. A pattern of assumptions being made by buyers without reading the fine print, and a pattern of buyers being surprised by the costs and penalties in the fine print. So today, I'm going to focus on 3 common assumptions by buyers, show you how they're likely to result in costs and penalties and problems for the buyer, and give you simple and easy solutions to avoid these costs on your next purchase. Is that a good use of our time together? Good. So let me start with my own fine print. This presentation contains my comments on 3 specific assumptions. It's not legal advice. Please obtain independent legal advice before making any decisions or signing any documents. Assumption 1. Buyers assume that the terms and conditions on the contract are flexible. I'm sure you've heard buyers often asking for an extension of the finance clause, an extension of the settlement period, the right to nominate another buyer, the right to access the property before settlement. By signing the contract, both the buyer and the seller agree to the terms and conditions on the contract. So when a buyer asks for an extension, a variation, or a nomination, what they're really asking is to change the agreed terms. The problem is that the fine print usually requires the seller's consent to any contract changes. The seller may not agree. Even if the seller does agree, the buyer usually has to pay additional costs to their own conveyancer, to the seller's conveyancer, and perhaps even the seller. The solution is to make sure you know what you're signing before you sign it. Check the contract with a lawyer and make sure the details are correct. And that's the parties, the purchase price deposit and balance, the settlement date, the subject to clauses, the special conditions, everything. Assumption 2. Buyers assume that the seller has to declare all problems and issues on the property. Under the Sale of Land Act, the seller has to only provide very specific, very limited information, like under the Section 32 and material facts. All other issues and problems on the property are subject to buyer beware. This means the buyer is responsible for investigating the problems and issues on the property before they sign the contract. One of my clients called a couple of months after settlement and said the jacuzzi is not working. So I asked him, did you check before you signed the contract? Did you check at the final inspection? And he said, I didn't check. He didn't check even though he was advised to check because he assumed it was working. The fine print in the contract says that the buyer buys as is. What that means is that the seller is only required to deliver the property in the same condition as it was when the contract was signed, subject to fair wear and tear. The seller is not required to fix any pre-existing defects or damages. The seller is also not required to professionally clean. The problem is that the issues on the property are rarely as obvious as the ceiling in that picture. The consequence to the buyer not checking the issues and the property is that the buyer is likely to incur unexpected costs in rectifying pre-existing defects and damages. So the solution is to make sure you know what you're buying before you buy it. Carry out very, very thorough due diligence investigations on the property. Check the property, including all fixtures, fittings, appliances, heating and cooling, doors and windows, boundaries, fences, everything. If it is at all possible, make the contract subject to a satisfactory building and pest inspection. Check the restrictions on the property, like planning and zoning, owners' corporations, covenants, etc. And also check the risks, like flooding, like bushfire-prone areas, and like combustible cladding. Assumption 3. The buyers assume that the seller will reschedule settlement. One of my clients bought and sold recently. The purchase was scheduled to settle 7 days before the sale. Because the buyer needed to access the equity from the sale in order to complete the purchase, they had to arrange for a deposit release, a refinance, and a bridging loan within a 30-day sale settlement. As you can imagine, the purchase settlement was delayed. The buyer assumed that the seller would grant a penalty-free extension of settlement. The seller did not agree. The problem is that the seller relied on the fine print in the contract to charge significant costs and penalties from the buyer. These costs and penalties were completely avoidable if the buyer had scheduled the purchase and the sale on the same day simultaneously. The solution is in 2 parts. The first is to get the settlement date right. Consider all the variables that will affect the timelines, like the lender's timelines, simultaneous sales, bridging finances, refinances, trust setups, fund transfers, everything. And the second is to be prepared for settlement, to make sure that the buyer, the lender, the conveyancer, and the funds are all ready for settlement on time. Today I've discussed 3 very specific assumptions of buyers. As you can imagine, this list is not complete. Please reach out to me for a more comprehensive checklist on your purchase or any questions. I leave you with this thought from Pete Seeger. What is the difference between knowledge and experience? Knowledge is when you read and understand the fine print. Experience is what you get when you don't. Yes. Yeah. So success in property is a team effort. It's a collaboration between the buyer, the seller, the estate agent, the lender, the mortgage broker, the accountant, the lawyer, the buyer's advocate, the building and pest inspector, the financial advisor. So many people need to work together collaboratively in order to make that purchase a success. So my best advice is to choose your team wisely. Thank you.